Happy to make the appointment.
When you are appointed conservator, you have authority to make decisions regarding the property and financial affairs of another individual, called a ward. Your letters of conservatorship will tell if you have authority over all of the ward's assets, or if your authority is limited to managing specific assets. Jim is conservator for his brother Tom. Their sister Jean is Tom's guardian.
I guess I look at being a conservator as I'm responsible for Tom's financial issues and his future. One of the largest concerns that we've always had is how do we conserve my brother's money? How do we make sure that if he lives to be 95 years old or 90 or however old he lives, that he has money for the rest of his life?
As conservator, you have a fiduciary duty, which means simply you are in a position of trust to act in your ward's best interest.
And as long as they're still living, their needs need to be met. And if that means I have to liquidate an asset in order to provide for their needs, that's my job.
Soon after being appointed, you must file with the court an inventory of the ward's assets.
Basically, identifying the individual's assets and also his liabilities, you know, how much he has in the bank, how much is his house worth, does he have a collection of this or that, does he have automobiles, does he have other property.
So I get a lot just through having their mail forwarded to my house, and you start getting notices of maybe life insurance benefits, and so the mail tells you a lot.
One of the things that we found when we first took over my brother's money is he had CDs everywhere. He had money in bank accounts everywhere.
You will also need to secure your ward's assets.
When we had full-time caregivers for my parents, it was amazing the amount of things that happened. Things disappeared out of the house, money disappeared, credit cards got stolen.
I've been appointed by the court as conservator.
Well, how I handle it with the banks is when I am appointed somebody's guardian or conservator, within 48 hours I'm at the bank with my letter of authority saying, this person has an account here, here's my letter that shows that I can act on their behalf, and then I usually transfer the accounts into the name of the estate. So the title on the account would be the estate of Joe Doe, with me as guardian or conservator, whatever it is. So I actually make that transfer, and then even though the account is tagged that it's that person's money, the only person who has authority to access the account or to write checks on the account would be myself.
Managing the ward's finances involves receiving and depositing the ward's income and investing assets, paying necessary bills, and handling tax matters, insurance, and other legal claims.
And trying to determine that the appropriate people got billed, the appropriate people got paid, and you didn't overpay.
You may also need to sell assets to pay for your ward's ongoing care and living expenses.
And this is one of the things that causes a lot of anguish between the family members, because a lot of them believe that they need to hide the assets, and that's against the law.
I've now exhausted her liquid assets, and she still, of course, is very much alive and still needs to have money to pay for the nursing home care that she receives. And the only thing she has left is the vacant property, which the children were hoping would come to them by rights of beneficiaries on wills and that kind of thing.
A conservator is not allowed to sell real estate without the court's approval.
And do you have any objection to the court approving the relief requested?
And the family at that point in time will receive proper notice under the law about what I'm doing and why I'm doing it, and they will have a chance to object. And then the court, if there are any objections, then the court will make the final decision.
You will need to determine if your ward has an estate plan, a will, or trusts.
I do have a duty to follow an estate plan if one is available, and in this particular case there were some estate planning documents. But again, that's where we sometimes come into problems with family members who get hold of the will and the trust in advance too, and sometimes think that those assets that may or may not be the last choice to sell is going to be their inheritance.
In some cases, money may have to be placed in a special account, with withdrawals made only on order of the court. Court approval may also be required before you make a large or unusual expenditure of your ward's funds.
He really needed the water therapy for a big expenditure like his pool room. We had an open hearing on that, and there were no problems at the hearing, and Brett got his pool room approved.
Here we go.
The things that he needs, Brett gets, but he's still maintaining the amount of money we think he'll need in order to continue on into the future.
When it comes to investing his money, we're very conservative.
Hey, Mr. Sailor.
Brett's estate includes a monetary settlement from a lawsuit brought after he was seriously injured in an auto accident. His conservator is his mother, Jackie, who is assisted by her husband, Brad.
When Brett first got his settlement, we looked around for different ways to invest it or where we should put it or what really to do with it, because we weren't used to dealing with that much of money all at once.
Conservators have a legal duty to invest funds according to the prudent investor rule. Simply, this means that you must use reasonable care, skill, and caution with your investment strategy, taking into account the circumstances of your ward's estate. Particularly with larger estates, you may need to seek professional advice from investment advisors, attorneys, or accountants who are familiar with the prudent investor rule.
Having somebody at a bank who will work with you is unbelievably helpful. One of the things that we looked at was, can we establish trusts? And we found a couple of attorneys who specialize in that. We stumbled through people who didn't specialize in it, and we spent probably some money that we didn't need to spend working our way through those problems. But we currently have several attorneys who specialize in conservator-type relationships.
One of the hardest things you got to do is assemble a team of people, because you can't do everything. And assemble a good team, because you'll meet a lot of people that are looking out for themselves, not the person you're taking care of.
You are not expected to use your own money for your ward. You may use the ward's funds to pay for professional services necessary to manage the estate, but be sure to get detailed statements and receipts.
And there again is an issue where you have to be very, very careful, because as you're aware, attorney bills can just get totally out of control.
You should avoid using cash to pay your ward's expenses, and you must not commingle your ward's funds with your own.
Why it isn't a good idea? Number one, because it becomes so convoluted. How do you know which dollars belong to who and that kind of thing? By not commingling funds, you've got a pretty straightforward record of everything that goes into the account and everything that goes out of the account. And it's just so much easier to decipher when you have to file those annual accountings.
Once a year, you must file an account of fiduciary with the court. The account of fiduciary is one way the court can oversee how you manage your ward's finances.
I think the difficult thing is that you do it once a year, and it is so detailed, and it has to balance, and there are so many requirements that you have to comply with. And it does take a tremendous amount of my time.
In some cases, the court may ask a conservator to post a bond that guarantees protection of the ward's assets.
We also review the necessity of a bond because we have some money here that's available that you will have full access to.
A bond basically is an insurance premium that I pay to ensure that I will not pilfer the ward's funds.
There are serious legal consequences for failure to perform duties of trust. Remember, if you have any doubt about the expenditures or investments you plan to make, you may ask for the court's approval in advance.
And I'm happy to approve the fees, and the order is now signed and filed. Thank you.
Upon the death of the ward, you must notify the court immediately, and your authority as conservator will end.
Once they die, we have about 56 days in order to prepare a final accounting, telling the court everything that's happened up until the point of death. If they have assets, usually a family member steps forward and either brings the will that exists and gets someone appointed to be the personal representative, and then we just follow the rules of the court and transfer everything over to that person, whoever the court designates to be the personal rep.
With conservators, please understand that this is not your money. This is your ward's money. This is your protected individual's money that you're given the responsibility of handling, and take that seriously.
If I had to give one set of advice, is ask a ton of questions. Find the people who you can go to who will give you direction. If you don't ask the questions, you'll never get the answers.